Hey everyone, this is Michael Miscoe with for this week's presentation of ChiroSecure's Growth Without Risk series. This week we're going to talk about mitigating post-payment risk relative to delegated services. Um, in my firm, I've gotten just a boatload of cases recently where payers, blues payers, a whole host of commercial insurance payers have been challenging physicians relative to their ability to be reimbursed for services that they delegate to assistants in their office. In some cases, those assistants are also either licensed or certified as massage therapists, and that kind of makes things a little bit stickier. But let's start in our analysis, by looking at licensure regulations. First of all, you need to validate in your licensure rules that you have the ability to delegate the services that are being performed by unlicensed or certified assistants in your offices. Some states have very clear delegation provisions. They have provisions for obtaining certification for your chiropractic assistants. Sometimes that's a formal certification process. Sometimes it's permissible with on-the-job training. Either way, you need to understand what your authority is to allow assistants in your office who are not licensed chiropractors um, to provide be involved as auxiliary persons in the performance of services. Because if they are not legally permitted to do what they're doing, then obviously the money's going to go back because you don't have the authority to bill it. So that's the first thing that you have to validate, is that these folks are legally doing whatever it is that you're asking them to do. The second thing is that we have to look at payer policies. Some of them allege that when you delegate the performance of a service, let's say take something simple like electric stim or traction, it's a little more complex when we're talking about therapeutic procedures, um, especially on the licensure side. Like, for example, Pennsylvania, chiropractors are permitted to delegate modalities, but they're not permitted to delegate therapeutic procedures. States Some states don't address it at all, and it creates a lot of confusion. Some states address it very thoroughly. But once you validate that this assistant, who is not a licensed DC, is legally performing under your supervision, whatever it is that they're doing, then you have to look at the payer reimbursement policies. And before we even get to those, we have to look at your contract. Most contracts allow you and require you to bill covered services that are within your scope of practice. Now, within your scope of practice, I would argue includes services for which a portion of the service is delegated to an auxiliary person who's not licensed in their own right to be credentialed uh, by the particular commercial plan that you're billing. Nonetheless, that concept notwithstanding, some payers consider that pass-through billing. And let me explain what pass-through billing is, because if you look in your contract, you may see a prohibition for it. Pass-through billing would be if you, for example, delegated the entirety of a service to another licensed provider who performed that service, and then you billed it under you. So, for example, let's say you had an independent contractor in your office, not an employee. He or she is essentially running their own practice. If they're an independent contractor, that's what it means. It's not a convenient term to label an associate who works for you so you don't have to pay workers' comp or do withholding. But an independent contractor is somebody who rents space in your office and they're essentially running their own practice. If they were to perform a service for you, but you would bill it out under you, especially if they weren't credentialed in your group, which if they're truly independent, they wouldn't be. In that scenario, that would be pass-through billing. However, delegation of a portion of the service, and we'll talk about what portion you are in fact delegating, um, that is not pass-through billing. That's what's called use of auxiliary personnel. It's common in the medical field. I mean, let's face it, nobody believes that the board certified radiologist is operating the CT or the MRI machine. Nobody believes that physicians take the entire history and do everything associated with all the care that's performed in their office. They use nurses, medical assistants. Um, and similarly, chiropractors traditionally use chiropractic assistants, whatever you would call them. Nonetheless, when you delegate something, you have to understand what you're permitted to delegate usually. The non-decision making aspects of a service. So if you look at, for example, the Medicare Physicians Fee Schedule database and how they value services, there are three components of value. The physician relative work, that's all um, uh, the brain power, didactic decision making, whatever. So you're doing examinations, diagnosis, developing plan of cares, determining the who, what, where, and where, how, why of a particular service. So let's say for electric stim, you have to determine where it's to be applied, what protocols to be used, how long, where to set all the dials and knobs. Okay. Then there's the performance component, which is the actual application of the therapy. So in that scenario, if I was your assistant, I would do what I like to call, and if there's any CAs on the call, don't get upset. It's what I like to call the monkey boy component of the service, meaning I don't get to turn on my brain. I do exactly what you tell me to do. I turn the knobs where you tell me to turn them. I put the electrodes where you tell me to put them. I turn the dials to where you tell me to turn them. I set the timer for the time indicated in the order. And that is what you're delegating to me. And in that scenario, as long as I'm not doing any decision making, then it becomes, if permitted under your licensure rules, a properly delegated service and billable under you, even though you didn't personally do all the work. You get to bill for the service, and it's a rule that comes from Medicare. It's called the Incident to rule, which essentially allows you to bill for services that are integral, although incidental, to your physician professional work that are performed under your direct supervision by an employee. Okay, so and that's a very large oversimplification of the rule. I do whole lectures on the Incident to rule, but that is the basic rule that is accepted throughout the insurance industry, that allows providers to bill for work that they didn't personally perform. For example, venipunctures, when they're doing blood draws, those are done by nurses. They get billed by physicians where they're covered. Nobody believes the physician is doing everything that gets billed out of a physician's office. And the same is true in a chiropractic or PT office. PTs use PT assistants, in which case their work becomes billable under the PT, because usually, and in fact, I've never seen it, no insurance company credentials a PT assistant. Because they're not qualified providers, even where they're licensed in their state. So they have to operate under the supervision of a PT, for example. Hence, anything they do at the PT's direction is billable under the PT. So that's the basics of the Incident to rule and what payers generally allow. Now, I've seen that challenged, and in many cases, it's because it's not clear in the documentation that the physician is actually controlling the care. And what I'm talking about is that fundamentally, from a documentation perspective, the doc is not writing an actual order for the therapy. So the one way, if you're using auxiliary persons, these are these folks that assistants that work under you. You need to write a detailed order, basically eliminating all the decision making associated with the service. And now, I mentioned in some cases, this issue comes up a lot where massage therapy is billed. And that's, again, a whole different topic in terms of whether it makes sense to bill massage therapy in addition to manipulation. But let's assume that it is, and the massage is being performed by a massage therapist. Okay, from a documentation perspective, if the only way you can get paid is under you, okay, the most important thing that you can do to mitigate a carrier's argument that it should have been billed under the massage therapist is that you examined the patient, diagnosed the patient, developed a plan of care, and wrote the specific order. You're telling the massage therapist exactly what soft tissue structures to address, what technique to use, how long to do it. Okay. And be mindful on the medical necessity side that you stick to the areas of direct complaint. No head, shoulder, knees, and toes, 60-minute massages. These are going to be focal massages, but you have to eliminate the decision making. So for delegated massage services, the one thing you never, ever, ever do is allow your massage therapist to write a soap note, because that becomes exhibit A in the carrier's argument that the massage therapist is controlling the care, not the doctor. Therefore, when that is true, then those services are not incidental, although integral to the physician's professional work. That's the massage therapist deciding on their own what they're going to do, in which case, as the decision maker, the service should is properly billed under the massage therapist, whether it's covered or not. Okay. So and that is where docs have unfortunately been forced into, some payer favorable settlements, because the documentation really wasn't there to give us a solid argument that the doctor was controlling the care. And yes, we can argue, yeah, well, I gave them instructions, whatever. But let's face it, when a licensed massage therapist is doing subjective and objective analysis and writing an assessment and a plan, and then we did this, and this is what we found, and they're playing doctor, I cannot make a successful argument that is a delegated service as opposed to a referred service. So interestingly enough, we asked the question, when is a licensed massage therapist not a licensed massage therapist? And the answer is when they're functioning as a chiropractic assistant. Some states, where they can have licensure and then they can also be certified as chiropractic assistants, you have to be careful making sure that you understand what hat they're wearing at any given time. So understand the distinction. If you refer a patient to a massage therapist and drop it in their lap and say, okay, uh, go to see therapist Jamie, and Jamie's going to take care of you, then Jamie figures out what Jamie's going to do, and Jamie takes his or her own notes, and Jamie determines what massage is going to be done, and Jamie then bills it under Jamie, assuming Jamie is a credentialed provider with the payer, or if not, it's an out-of-network service, and if it's not covered, it's not covered, and they bill the patient. That's a referred service. A delegated massage service would look like this. As I mentioned before, the licensed DC examines, diagnoses, develops a plan of care, writes a treatment order for massage, and orders Jamie to do exactly what the doctor wants Jamie to do. And Jamie's note, if anything, indicates perform massage pursuant to Dr. So and so's order, dated whatever, for X minutes. And that's all Jamie says. Um, Thereby demonstrating that Jamie never turned his or her brain on. They just did what the doctor told them to do. And with respect to all delegated services, that's what the note should look like. If it's therapeutic exercises, the doc's got to write an order, sets, reps, weights, whatever, specify exactly what's to be done, to the extent that an assistant is there for purposes of safety, providing one-on-one contact, fine, but the physician should still be there to provide the skilled aspect of the contact. And this is where procedures get a little problematic in the delegation realm, because the contact requirements require skilled contact for exercises and therapeutic activities, and it's questionable in many states whether CAs can perform that, can provide that level of skilled contact. Long story short, be very careful with delegated services. Make sure your documentation is tight. Make sure you understand, the incident to rule relative to your authority generally. And when you're dealing with people that have other licenses, okay, maybe you've got a, medical neurologist, that decided that, the medical neurology gig was too, um, uh, stressful, and they just want to be a chiropractic assistant. Fine, park your degree out in the parking lot. You're a chiropractic assistant. That's how they represent themselves when they're working in that role, and they do what they're told. Okay. So with that, I hope that gives you some help as to how you might insulate yourself from post-payment liability relative to delegated services. Your other option is do everything yourself. That may or may not be possible depending on the scope of the services that you offer and the number of patients you see. But if that's your approach, that works too. Next week, ChiroSecure is going to be presenting Dr. Janice Hughes. I'm sure that'll be an engaging presentation. And until next time, we'll see you later.